Detective Ratzburg, during the break, I'd asked you to count some things up for me. It looks like you're still just finishing that up.
I'm finished now, just finished.
Oh, okay. I asked you to take a portion of the log and count the telephone calls that were hang-ups or out of areas from May 96 through August 96. Is that right?
I have, yes.
How many telephone calls were there during that time?
Well, what I did is I thought you said just the out of areas. And
Okay.
just the out of areas that are before 5 p.m. are 8.
8 calls before?
Yes.
And how many after 5 p.m.?
4.
4?
Yes.
Okay. And then were there, and that's during that 4-month period?
Between 596 and 896.
Between May and August?
Yes.
And how many, I'm sorry, what page is that on?
Page 30, well, quite a few actually, but 38 and 39. I think page 39 might be of interest to you.
Well, I apologize for my directions because I'd hoped to get hang-up calls. Well, and there's also a page with numerous out-of-area calls that I think you must not have counted, the loose page that we previously marked as an exhibit.
I did not count that.
Okay, well, we'll come back to that. We'll come back to that later rather than having you count calls right now. You have another exhibit in front of you, Ameritech,
Yes, right here.
and is exhibit 264, is this found in Julie Jensen's log?
Yes, it is.
And it appears to be a letter from Ameritech to Mark and Julie Jensen
Yes.
regarding traces that were put on their phone in September, October, and November of 1995. Is that right?
Yes.
I'd move defendant's exhibit 264.
Objection?
No objection, Your Honor.
And do you have that in front of you, the original?
Yes.
What we have is a September 27th, 1995 letter from Ameritech. That's the date.
Yes.
And there's an indication that they'll put a trace on, correct?
Yes.
And that they should keep track of any telephone calls, correct?
Yes.
And on the second page, there's handwritten notes that are behind you. October 25th and October 26th, there were calls, correct?
Yes.
And then there's a follow-up letter on November 14th that's behind you, indicating that they're going to continue the trace for another 21 days, correct?
Yes.
And this is to both Mark and Julie Jensen, right?
Yes.
And the page that follows appears to catalog the various calls that were made over the next several weeks, correct?
Yes.
And they indicate that these were reported to Ameritech, true?
Yes.
On December 3rd, 1998, when you were at the Jensen home, you had an opportunity to observe the body of Julie Jensen, correct?
Yes.
Your report does not note any unusual observations about Julie Jensen?
Yes.
You agree that it does not?
Yes.
Your report doesn't say anything, for instance, about the condition of Julie Jensen's nose, right?
don't believe, no.
You had never written a report on that subject, true?
True.
When you met with Dr. Chambliss the next day, did you mention anything to him about the nose?
Probably.
Do you recall any specific conversation with him?
I pointed it out to him. I said I had a concern. I mean, I know I did because I took photos of it, that and of her eye. And I certainly would have called it to his attention.
You've seen the autopsy protocol, correct?
Yes,
Dr. Chambliss did not note anything about the nose there, correct?
correct.
He didn't, you've seen the autopsy photos as well, right?
It's been a while.
Are you
But I've
aware-
seen 'em,
Are
yes.
you aware of any autopsy photos of the nose?
No,
You weren't asked to take any of those at autopsy?
not that I recall.
You had a meeting with Dr. Chambliss and Dr. Lavin, I think you testified to sometime in March of 1999.
Yes,
At that time, you reviewed the photographs you had taken at the scene, correct?
yes,
And the reports that you had.
yes,
So Dr. Chambliss saw those photographs of the scene, right?
I believe so, yes.
At the home on December 3rd, one thing you had to do was find, let's just say, a placement for Mr. and Mrs. Jensen's dog. You recall that?
Yes,
They had a dog, right?
yes, they did.
When you were going through Mrs. Jensen's daytimer yesterday, you noted the heartworm hearts, right?
And I vaguely recall that on December 3rd, there was an issue with a dog.
Are you aware as to when Mr. Jensen would take that dog out in the morning?
I'm not.
Do you recall what kind of dog it was?
No,
Following Mrs. Jensen's death, from approximately December 6, 1998, until about December 20th, maybe about a 2-week period of time, you had a GPS unit placed on Mr. Jensen's car, correct?
that sounds about right.
You had him come in to see you on December 6th,
Yes,
and at that time, unbeknownst to Mr. Jensen, some other law enforcement agents placed a GPS unit on his car, right?
yes,
That was for the purpose of monitoring his activities over the next couple weeks, right?
yes,
And you traced during those couple weeks wherever his car went, right?
yes,
And you didn't find any information of any value to you in this case, true?
true.
Exhibit 232 is Mr. Jensen's daytimer, correct?
Correct.
When you seized this daytimer from the home, it was a leather-bound item, correct?
Yes,
When you gave back some of the pages to Mr. Jensen, you also gave him the leather-bound cover so you could continue to use this calendar, right?
yes,
You understand from reviewing this and that it was leather-bound, it was a ring binder kind of thing?
yes.
That there are replacement pages so that you don't have to get a new leather-bound cover each year, right?
No, I'll take your word for it. Yes.
Okay. I mean, is that how it appears to you?
That would seem to be an accurate description.
Later on, you seized some other years of daytimer from Mr. Jensen, correct? In 2004, you seized daytimers from
yes.
that pages from 2000 and 2001, correct?
Yes,
And those also could be inserted in a ring binder, right?
they're considerably smaller than this one.
Okay. And the You kept November, is that right? The November pages?
Yes.
You also kept...
Which day timer?
I'm sorry, what exhibit number is that, Mr. Ratzburg?
This would be, I have the November pages for S232.
232. There also are calendars that you kept, right? I mean, there are two parts of it. There's like a daily November 1st, November 2nd, November 3rd, and then for each month, there's like a calendar, like you hang on your
yes.
wall. You kept all the calendar pages, am I correct?
Yes.
But gave him back his daily portions of that from January through October, right?
I believe it's through October.
In addition to the dated daytimer pages, there also are blank pages for taking notes, correct?
Correct.
And Mr. Jensen took notes on some of those pages, right?
Yes.
And you kept those notes that he had on those blank pages or undated pages.
Yes.
Those aren't something you gave back to him, true?
True.
I'd ask you to turn to the page for November 4.
Yes.
There's a portion of that page behind you.
Yes.
What is written on November 4 is withdrawn, lays on bed, knees pulled up to chest, aspirin, dash, a lot, not dealing with life, day-to-day activities too much, crying. Is that right?
Yes.
Did you understand from the interview we watched yesterday that Mr. Jensen was writing these notes to keep track of his wife's behaviors?
Objection, Your Honor, calls for speculation on the part of this witness.
Well, you can answer as to whether he understood that from the statement that was played yesterday.
Yes.
Please turn to November 5th. And a portion of what is written on the daytimer for November 5th is called till 1:30, starting at 11, no answer, finally Buddy did, couldn't wake up, groggy, correct?
Yes.
You understood that these notes are, well, that November 5th is...
Excuse me, that's probably the other call. Go ahead, sir.
Detective Ratzburg, returning again to the entries on November 5th, you understood that on November 5th, Mr. Jensen was in St. Louis?
I believe so.
Please turn to November 9th. And the last entry was that was Thursday, November 5th, correct? Well, the last one we had just been looking at.
Yes.
And then November 9th, the following Monday, one of the notes reads, puked on carpet over weekend, got into it whether to get it cleaned. Is that right?
Yes.
And Mr. Jensen had told you during the recorded statement we observed yesterday that while he was in St. Louis, his wife had gotten sick in their home and not cleaned it up. True?
Yes.
Please turn to November 16th. Part of what's written there for November 16th, Detective Ratzburg, is withdrawn kids, boat-Jolinsky, locked chest, crying about miscare, probably short for miscarriage, correct?
Yes.
Turning to November 17th. Part of what we have written there is Gateway. And there's a technical college in Kenosha, Gateway Technical Institute, is that right?
Yes.
Locked chest, locked in bedroom morning, 8:50, too much to do. You know what the next word says? Is that meal?
I think it possibly meal or Neil, one of the two. I believe it to be meal.
Cruise, jobs-quit, crying about miscarriage, suddenly detached, itinerary for week, locked in room when I got home. Correct?
Yes.
November 18th, we have a note for a Susan Schneider and a telephone number. Do you know who Susan Schneider is?
I do not.
Turning to Monday, November 23rd, toward the bottom of the page. There it says, crying, when I got home, new game, going to keep David, Doug, diaper, conference, GTI, not happy. Is that what it says?
Yes.
And GTI would be Gateway Technical Institute, or that would be one thing it could be?
Likely, yes.
Do you know whether Mrs. Jensen had ever attended Gateway?
I'm not sure.
Following the interview with Mark Jensen on April 21st, 1999, you spoke with David Jensen, correct?
Yes.
For about an hour?
Yes.
You did not videotape record that statement?
Correct.
Could you please turn to page 20 of your narrative report?
Yes.
What David Jensen told you is that his mother had labored breathing.
Objection. This is hearsay, Your Honor.
Judge, it's 90806 because we've previously introduced hearsay statements of Mr.
May I see the document?
Are you on page 20, Counselor?
Yes.
What paragraph?
Second, I think it is.
The objection's overruled.
David Jensen told you that his mother had had some breathing difficulty on December 3rd, correct?
Yes,
The day of her death?
yes.
And that he had told,
Your Honor, I'm sorry. Could we approach for just one moment? I don't want to make an argument in front of the jury, and it'll be very
You're
brief.
not going to make a secret argument either. I have to tell you, I'm pretty
He said that
sure that you're not going to change my mind.
I'm not trying, I don't want to change your mind. I'm
Then why
not
do you want to
opposing
come
you
up?
coming in.
What?
I'm not opposing you
Come
coming
on
in.
up.
Detective Ratzburg, in addition to telling you that he had breathing problems on December 3rd, he told you that he had told several friends about the breathing problems on December 3rd. True?
Yes,
David Jensen also told you that his dad said that if his mother was worse later in the day, they would take her to the hospital, correct?
yes,
And that was in response to David's question of whether she needed to go to the hospital, right?
yes.
There was some discussion, Detective Ratzburg, about Julie Jensen's arm and how it was situated in the photograph. Do you recall that?
Yes. You're speaking of my interview with Mr. Jensen?
Yes.
Okay.
And you sleep like that, true?
I could.
Well, have you said that? Have you said that before, that you sleep like that, as depicted, as Julie Jensen is depicted in the photograph?
I don't know if I sleep like that or not. I mean, I certainly could. We toss and turn. Some nights you're more restless than others. Is it possible? Yes.
One of the exhibits that was introduced today was the printout of Paxil information. Is that right?
Yes.
Is that? Do you have that in front of you?
I can get it, sir.
Pardon me?
I can get it.
Oh, sure, please.
I don't know if that's totally marked as an exhibit, though. It may be.
I think
But
it is. It would be States Exhibit 242.
Okay. And those are pages that you received from Mark Jensen, right?
We recovered this on December 3rd.
That was at the home?
Yes,
did you talk to Mr. Jensen about it?
Yes.
At the time?
And that's what he said he
Objection. Hearsay.
Well, I don't, it's hard to say right now.
Oh, it's real easy to say. He was
well,
going to make
no.
a factual assertion, and it's a hearsay statement.
Yeah, it certainly has that potential, so I guess I'm going to have to see something that would give me an ability to anticipate the answer.
All right, well, maybe I'll come back to that. Do those appear to be printed off a computer?
yes.
At what time?
I don't see a time on here.
Okay. There's no date or time printed on those?
There is a date, but I don't see it. The question was a time, correct?
Sure. Okay. It appears that they're printed on December 2nd, 1998, but there's no time stamp on the printing. Is that right?
Correct.
we observed the video that you had taken at the home, right?
Yes,
You indicated that that was two separate videos. Is that right? You took that at two separate times?
better said, I took it at 2 separate times.
Do you have anywhere an indication as to what time precisely you took the first video, when that began?
No,
Do you recall at the conclusion of that video saying that it's now 7:46 p.m.?
that's likely.
I beg your pardon, I didn't hear your answer.
That's likely.
Is that what you recall, that it was 7:46 when you finished it?
I believe it was, I'm just not sure of the 7-something, I'm not sure of the 46.
How long was that video, do you know?
Do not know.
Was it immediately before that video that the photographs were taken in the home?
Say that again?
Was it immediately before that video was shot that you took the photographs in the home?
No, we took photographs previous to the video. If you look at the video in the den, you'll scan across and you'll see 3 rolls of film that were taken by Lieutenant Hunter. So I know that we already took photos, and then the video was after that.
That's what I'm asking. Was that immediately before you shot the video that you took the photographs?
Yes.
So would it be fair to say?
No, let me back up. Not immediately. I know photos were taken before I did the video.
What time were the photos taken?
I don't know.
Did you log in what time the photos were taken?
No.
Don't you think that might be important in a death investigation?
Objection.
Sustained.
Well, in your training, have you been taught that the timing of photos when there's a death involved could be important to experts examining the case?
Usually through the training is it suggested a photo log be started or taken, and we didn't do one in this case.
You did not.
We did not,
Detective Hunter took the photographs?
for the most part.
Would it be fair to say the photographs probably were taken around 7:15, 7:30?
It's approximate.
There's no report that you're aware of anywhere identifying precisely when the photographs were taken, correct?
Correct.
In that video, do you recall noting at the beginning of that video that the body has been disturbed by firefighters?
Yes.
That was your understanding as to the case, right?
Yes.
That the body had been disturbed by firefighters?
Yes.
In that video, my recollection is that you were touching things with your bare hands. Is that accurate?
In the video, yes.
Would you have been trained to use gloves when gathering evidence at a potential crime scene?
Yes.
You did not use gloves?
If you look at some of the other photos, on some of them I wore gloves, and on some things I didn't. I think it depended on the type of evidence. I can show you a photo here if you'd like.
Well, you were touching some things without gloves, is that fair to say?
Correct.
Mark Jensen spoke to you on December 3rd, right?
Yes.
You spoke again with him on December 6th.
Yes.
You spoke with him at least weekly through April 21st, 1999.
Fair statement, yes.
April 21st, 1999 is the recorded statement that you took.
Yes.
One thing that you were looking at was the suspicion that the Paxil or the Ambien or both may have had something to do with Mrs. Jensen's death.
Yes.
You had even received information from from a nurse who was the wife of one of your officers that she thought that those could be a cause of fatal interaction, right?
I recall something to that effect.
Were you aware that Julie Jensen had gone to college to be a nurse?
Yes,
Were you aware that she had come close to completing her coursework for getting a degree in nursing?
yes,
Are you a hunter?
I used to be. Cold and snow, when you get to be my age, begins to affect you. But I used to be. I'm quite familiar with hunting, yes.
Okay. Well, I really was just getting at, did you go hunting in 1998?
I could have.
Do you recall if you were working during the weekend of November 21st when Mr. Cosby was on vacation?
I thought you were going to ask me if we were going to go hunting. I just don't recall if I went hunting that weekend, as did Officer Cosman. I just simply don't recall. I could have.
You indicated that you'd spoken with Julie Jensen perhaps 5 times, a couple times in person, 2 or 3, 4 times on the phone.
Yes.
She talked to you about her sex life.
Yes.
Did you find that unusual?
Meaning what? Her talking to me about sex lives, or do other people talk
Yes.
to me about their sex lives?
Whether, maybe it answers the same question, but did you find it unusual that she was talking about those things?
Not really. Being a police officer and my years of experience, people confide in you a lot.
Is that something they call the police for?
Yes.
On April 21st, 1999, that's the recorded statement that we saw part of yesterday, right?
Yes.
You asked Mr. Jensen to stop by the police station, right?
Yes.
As we discussed, you'd met with him at least a dozen or more times over the preceding months, correct?
Correct.
The longest conversation you'd had previous to that was maybe an hour?
It's probably fair.
On this morning of April 21st, you told him that you just wanted to have a touch base with him about some information you had, correct?
I can't remember our exact words. I made an appointment for him to stop by about 9 o'clock in April. I don't know whether I prefaced it with that. I just don't recall.
He told you that he'd stop by on his way to work?
Yes.
We can see in the video that he's in shirt and tie and jacket as though he's going to work.
Yes.
You did not tell him that you planned on interviewing him for the entire day. You had been planning this interview for several weeks.
To some extent, yes.
You did not indicate to Mr. Jensen that you intended to have this kind of interrogation, right?
Fair statement.
Your prior conversations had been in offices or conference rooms or Mr. Jensen's home.
No, I don't recall having one at his home. He usually came to the police department to meet us, and that was by my design so that we could put the GPS on his vehicle. So I always insisted that our meetings be at the police department.
But you had other conversations after that one with him, right?
Well, there was more than one time with the GPS. We had it on continuously. So there were several times he came out to the police department.
And on none of those occasions did the GPS produce anything that you thought was evidence in this case, true?
True.
But your prior meetings with Mr. Jensen at the police department had been in an office or conference room, correct?
Correct.
On this occasion, you brought him into a small interrogation room, right?
Correct.
The, maybe a 10 by 6 room, something like that?
Oh, it's bigger than 10 by 6, but 10 by 8. Again, you can fit 3 people in there, obviously, comfortably.
Even if you're one of them?
Yes, yes.
But that is what that room is for, is an interrogation room as opposed to like a conference room.
It's designed to interrogate or interview people, and the reason I selected that room is obviously because I wanted to record our conversation. So that's why I selected that room, so that we'd have the taping capabilities.
It was set up for that already, right?
Correct.
Mr. Jensen was not advised that this interview would be tape recorded, right?
Correct.
You then proceeded to interview Mr. Jensen for maybe 7 hours, is that right?
Yes.
There's an hour and a half of videotape that's missing, right?
No, I have the videotape.
Well, there's an hour and a half of interrogation that was not recorded by the video. That'd be accurate.
Yes.
I mean, there is some sort of technical difficulty.
Yes.
So there's a middle hour and a half, a little bit after lunch, that's not recorded.
I'm not sure if it's an hour and a half, but there is a segment when me and Mr. Jensen spoke that is missing off the tape. I still have the tape.
But there's nothing
There's
on it.
nothing, there's nothing on it. Correct.
You've been trained in interrogation techniques?
Yes.
You learn things like you discussed yesterday about lying to suspects about evidence, right?
Yeah.
You learn techniques like to use persistent questioning of the suspect, right?
Sometimes.
Maintain control of the interview, right?
Try to.
Sometimes use humiliation, right?
Sometimes.
Sometimes by trying to leverage a perceived friendship with the person, right?
Sometimes, yes.
And your training is that sometimes that will cause a person to, all those kind of techniques will cause a person to speak more freely with you.
Sometimes.
But that's what you're trained to do. That's the purpose of doing those kind of things, right?
Sometimes.
Well, is there some other purpose that you'd be using those techniques for?
Well, it depends on what kind of discussion you're trying to have or what information you're trying to obtain. Varies.
You were trained as well that you have to be careful about the danger of promoting false confessions, right?
Absolutely.
You're aware that there are cases in which people have been convicted for crimes they did not commit because police lied about the evidence they had against them, right?
Objection is completely irrelevant in this case.
I'm not aware of any specific cases, but, to prosecute or to investigate a case strictly on a confession is not something we would do, and most places don't.
Well, are you aware of the case of Gary Gauger, who confessed in the Rockford area to murdering his parents after the police falsely told them that he had fingerprints at the scene?
Sustained.
Well, may I approach, Judge? It'll be brief.
Well, we're going to take one more recess this afternoon, so maybe we'll make this it, and then we can deal with your other matter too. About 10 minutes. Mr. Jambos wanted to further object. Well, why don't you state what you wanted to summarize, what your position, you'd probably do a better job than I would.
Well, the conversation that the witness, Mr. Albee was eliciting from this detective was a hearsay conversation. It is completely different from the communications that we had elicited from this child about this child. Conversations that occurred on December 3rd or December 2nd, 1998, between him and a schoolmate. This was a conversation that occurred April 21st, 1999, between this little boy and this detective. It was a hearsay communication. It should have been excluded. However, the court allowed it in over the state's objection. And then the point that I wanted to make is that the other conversation where we had gotten it in over the defendant's objection on the grounds that it was excited utterance, the court had raised this issue about confrontation and said that because of that we were going to be required to produce this child. Of course, this child is available, and now he's 17 years old. I don't want to describe him as he's 8 years old anymore. He is available by agreement between the parties because we had served a subpoena on David Jensen, and we have an understanding with defense counsel that if we ask for him, they'll produce him within, I think, 24 or 48 hours. It's the state's view that that counsel's been able to examine this witness now regarding David Jensen's recollections about what occurred on December 3rd, 1998. And even though it was a hearsay communication and it was obtained over the state's objection, I believe the state should be relieved of its obligation to produce this child for cross-examination by the defense. Having said that, if David Jensen is produced, and the understanding is that defense counsel gets to cross-examine him regarding this statement, then it would be the state's view that they only get to cross-examine him about that particular issue, that any other issues they wish to raise, they need to conduct a direct examination.
Well, I'm not going to reach that issue. Your point may be a very good one, but since we don't have that particular witness here now, I'm not going to give you a hypothetical ruling. I did point out to you at the sidebar, however, that the state doesn't have confrontation rights, as does the accused.
I accept that proposition, Your Honor, but nonetheless, the conversation that...
The conversation with the officer again?
It occurred on April 21st.
In thinking about it, I think you perhaps were correct.
Judge, under 908...
Late though, maybe. I appreciate the court sentence.
Now that the evidence is in, go ahead.
Well, under 90806, I can elicit inconsistent statements of a hearsay declarant.
But who's the
The declarant is David Jensen.
But they're not inconsistent.
Yes, they are. We have other people trying to claim that he made statements on December 2nd. He says that he made it on December 3rd.
But let me see that statement again. Why argue about it?
Right.
Because the evidence is in, and I'm just admitting it's within the realm of possibility that I erred, but whether I did or not, the evidence is in, and it's done.
And on the confrontation issue, though, I don't want any misunderstanding. I still believe...
No, I don't want to argue about the confrontation because the witness is not on the stand and has not been produced, and when somebody wants to call, either party wants to call that witness up here, then I'll rule on it.
I know, but I've previously objected on confrontation grounds. I still believe that there's a violation of Mr. Jensen's confrontation rights because the state elicited statements of David Jensen without calling him as a witness, and I continue to assert those.
And I again want to point out that ruling, and I want to be clear on this, it was not received just as an excited utterance. It was actually received more, the thrust of the ruling was that it was received as a then existing mental, emotional, or physical condition statement that is under subsection 3. And first of all, it's a non-testimonial statement. So you have no constitutional confrontation right at all with respect to that.
I do under Roberts, which our Supreme Court still recognizes.
Except that a then existing mental, emotional, or physical condition is a well-rooted exception to the hearsay rule. And let's look at it. Again, whenever you rule on any evidence, you have to look at the basic reason for the rule, and you can't just try to fit it into one thing or another. The thrust of the rule is the hearsay rule is designed, I've got actually a good quote on it here somewhere in my materials, but it's designed to keep out unreliable evidence that somebody concocted for improper purposes. And the risk of that is so low when you're talking about one 8-year-old talking to another. And that's why, by the way, that, and I don't want to get into English law, but the English Civil Evidence Law of 1995 provides that hearsay evidence is not grounds to keep it out. No hearsay. Hearsay is admissible in civil actions in England. And what's that got to do with this here? Nothing, except that it shows that the finder of fact should have as much information available as possible, and that when a judge rules on a hearsay objection, the judge should be thinking, what's the purpose of this rule? It's to keep out unreliable information. And on the reliability meter, a non-testimonial statement by an 8th grader to another 8th grader, my mom is sick.
8-year-old, not 8th grader, 3rd grader.
3rd grader. My mom is sick, and again, this is why the excited utterance is not really the important aspect of this. It's a then existing mental, emotional, or physical condition. The declarant was relating his then existing fear. Now, that may have been formed on the basis of past information, but his then existing fear was that his mother was having difficulty breathing and that his father wasn't taking mother to the doctor.
To the hospital.
To the hospital. So,
Well, I have to say that an 8-year-old reporting 9 years later what an 8-year-old had told him 9 years earlier, I can't imagine anything more unreliable.
that's for the jury to decide.
Well,
You're asking me to bar the door on that basis, which is actually quite separate from the hearsay rule. That's the credibility rules, which the jury will decide.
I disagree, but there's also, and since we're on this, I still have my confrontation objection to the admission of statements by Paul Griffin to Dr. Mainland, for which.
Well, I didn't open this up for a field day to rehash all the rulings of this trial. I only brought it up because we were talking about David Jensen in this case, and I recognize now that. Can I see the particular? No, let's not. Let's not take any more time to talk about a ruling that's already been made and evidence that's been received.
The other issue is what's the currently pending question, which I was trying to ask him if he was aware of a particular case in this vicinity where the police induced a false confession out of a person. And the reason this is admissible is because Detective Ratzburg was allowed to tell his war story yesterday about how he was able to get a guy to confess who had stolen a motorhome or something like that, and to act like these things don't have any downside. And he was telling the war story to make it sound like this is the greatest thing since sliced bread to the jury, and the guy who spent a bunch of years in prison for this killing in Illinois of his own parents, he probably doesn't think that's such a great idea.
Well, his point is not so bad when he talks about the war stories.
When he puts it like that, it isn't. But let's go into that. My understanding is that was a very young person. I think he was a teenager or just past being a teenager at the time that he was confronted with these alleged fingerprints. We have no idea how long that interview took place, how many people were in the room with him. With respect to the story, the true story about the person who stole the motorhome and fessed up, it's a typical means in which this is done. Now, in terms of all these other circumstances, there are horror stories where police officers lock themselves in a room with some guy and browbeat him for hours and hours and hours, a person of subnormal intelligence or a very young person. That's not what happened. This thing was on videotape. And furthermore, this defendant didn't confess to a crime that he did commit or didn't commit.
He made certain admissions which were damaging. And
correct.
Whether you make a full confession or just cough up something that is somehow favorable to the state, I'm not sure that I see the distinction as being one that ought to be emphasized. I think the reason I'm going to sustain the objection is that the detective, when he testified, gave a general statement about a particular case without identifying any particular set of facts. He talked about, he talked about a real case, but he didn't get into great detail about the particular case. And you're obviously going to talk about an individual case not involving the officer. He's acknowledged that there is such a risk. I think he answered yes to the question of whether or not people have confessed to crimes which they did not commit. And I suppose you could follow up with a question like, even in serious cases like murder, that's happened, yes? And I suppose that's it. And to get into all kinds of particulars, that's way beyond what the district attorney did.
Well, I thought I should be able to spark his memory with a rather well-known instance of
Well,
this.
is your memory ignited?
No, I'm not familiar with the case.
Well, I don't, in the remaining couple of minutes of the break, perhaps you can discuss it with Mr. Jamboys about that particular case? And then he can answer the question.
I don't know anything more about that case than he does. I don't know anything about that.
Just chatting about it. It was about how he was a young man and fingerprints and...
I know of a case. I don't know the name of that case. I know of a case involving a couple that were murdered by some outlaws, some members of the outlaws motorcycle gang. I don't know if this is the case he's talking about.
He knows a lot about it.
Okay.
We'll call you as a witness then.
And there was, I don't believe there was any physical evidence connecting that young man to that murder.
This is exactly why I don't want to get into it. I don't want to get
into it either.
Stallings case again. We don't want to talk about these other matters and get sidetracked. We're now 21 days into this case. This is day number 21, and I do not want to keep going and going. I think that it's a fair cross-examination because you did have the detective, the lieutenant, talk about the
case he knew about.
Advantages to be obtained from lying to defendants.
A case he knew about.
And I think it's fair, acquainted. There are cases. Those of us, let's not play games. We're all experienced in the criminal law. You know very well there are notorious criminal cases in which people have confessed to crimes which they did not commit, in part based upon, there was a case down in Texas we heard about at the judges conference 2 years ago where a man who was innocent, and there's no doubt about it. This is not one of these amorphous things. This is clear that this man is innocent now. Had been drinking to excess with one of his friends, that the police suspected them of committing a murder, and they were told each of them separately, well, the other guy has confessed and he names you as having done thus and so, and the fellow eventually confessed to committing a murder he didn't commit in order to avoid the death sentence. This is a real case. So we know these things go on. I don't want to spend a lot of time on it, and I don't want the jury. The jury has been left with the impression, that only good things can come from the police lying to defendants. And I think the defense has got a right to suggest that is not always the case. And let them decide.
Judge, I asked this detective about his experience with using that tactic. And if defense counsel wants to ask this witness about whether he's ever railroaded somebody to prison who is not guilty of a crime, then have at it.
His questions.
Because this one police officer is now going to be cross-examined about what 67,000 other law enforcement officers may have done across this entire country?
His questions do not have to exactly track yours.
I know they don't.
He can ask other questions. Haven't you heard of cases where people have committed confessed to crimes that they didn't commit?
Okay. By the way, I declined the invitation to
Well, he's already heard it from me. So if he's asked, have you ever heard of a case where a man was convicted of a crime he didn't commit?
And he can say, I don't know anything about
false
that.
evidence, he can say, yeah, I have heard of such things.
Yeah.
And I'll be his corroborative witness. I told him.
I anticipate some objections along these lines, Your Honor.
Well,
I will be objecting because this officer, unless they're asking about something this officer has been involved in, I don't think he should be obligated to testify about hearsay.
Mr. Jamboys, if you think I'm going to sit here and let the jury get a false impression about the benefits to be obtained by the police lying to defendants without allowing the defense to show that there may be detriments from that? No, it's not going to happen in my courtroom, okay?
Okay.
All right. 5 minutes.
So, well, okay. Oh, thank you, Judge.